Start recording, I think. Mr. Thakur, it's 1:30. I guess we can begin. Keep
Yeah,
letting
sure,
people.
sure.
Sure.
Yes, yes.
So I would like to formally introduce Mr. Avinash Thakur, who is here with us today, delivering this masterclass on patenting. Mr. Thakur is the CEO of AIC Pinnacle Entrepreneurship Forum. Mr. Avinash Thakur has joined as a CEO of the AIC Pinnacle Entrepreneurship Forum, and the AIC Pinnacle is supported by Atal Innovation, a flagship initiative of Niti Aayog, Office of Development Commissioner, Ministry of MSME, and Ministry of Electronics and Information Technology, Government of India. He is supporting an establishment of IPR vision and patenting strategy for various research labs, academic institutions, small and medium, small and enterprises in India towards systematic invention, creation, high quality patent portfolio building, and management of intellectual property and startups. He has a global exposure and is associated with various government bodies and international universities in terms of innovation management, IP related areas, and incubation related activities. He has also been invited as a keynote speaker to Purdue University, Indiana University, USA, as well as Amity University, Dubai. Thank you so much for taking out your time to be with us here
Thank
today.
you. Thank you. So, shall we start?
Absolutely, sir. Go ahead.
Okay, so any protocols for this session, or I have to discuss the strategy as a overall, and we will take up the questions from the participants. In that way, we will have to go.
Sure. So we can introduce patenting and the patenting strategies from you for
Right.
half of the session, and the other half we can have the questions in the chat
Fine,
box.
perfect. So we are having total 40 minutes. I am here for the 40 minutes span of time. So in first 15 to 20 minutes, I am going to cover up the basic ideas related to intellectual property and the patenting strategy. I'm not going to show any PPT kind of thing. In general, I will talk in between. You can moderate the session, or if anyone is having some kind of query, so we can have interaction. And in last 10 to 15 minutes, we can take up the questions from the participants. So basically, patent is one of the intellectual property. If you will understand the overall intellectual property, the meaning of intellectual property is those properties which is created through the human intellect. So any kind of property which is creation of the human intellectual, that is known as the intellectual property. So there are various intellectual property, like copyright is one of the intellectual property, patent is one of the intellectual property, then GI, geographical indication, is one of the intellectual property. Then semiconductor layout design is one of the intellectual property. Design registration is one of the intellectual properties. So all are individual intellectual properties. So we cannot cover up each and everything, but I will give you overall idea of all these intellectual properties. It's more specifically related to patents. We can take up couple of the examples so that all the participants from the startup point of view, they will understand that what are all those intellectual properties. So we will start with the patents. So patent is one of the intellectual property. So there are three criteria which is required for filing the patent. So if any startups are doing some kind of product development or some kind of process development, so they can go for filing the patents, but they will have to fulfill three criteria. First criteria is novelty. Second criteria is inventive steps, and third criteria is industrial application. So we can take the example, couple of the examples. So UPIN, paperclip, we all are using paperclip UPIN. So that is the patented product of 1800 century. So UPIN has solved what kind of problem? Basically, in 1800 century, there was not any that kind of device for tagging the papers, and UPIN has solved that problem. So the moment I am saying novelty, so the day on which we are filing the patents, on that day there should not be existence of any that kind of product in terms of literature, in terms of any kind of products availability. So it should be complete novel, new thing should be there. Sorry. Second step is inventive steps. The process, the mechanism through which we are developing that product, it should have some inventive steps. And third is industrial application. Whatever be the things we are proposing, it should have that capability to get launched into the market. So we can take the example of umbrella. So umbrella is again a patented product. So umbrella, the mechanism, the process through which that umbrella is getting operated, that is inventive stage, the day on which patent related to umbrella got filed. The second thing is the inventive steps and the industrial application. Umbrella is having that kind of capability to get it launched into the market. All the pharmaceutical products are the patented products. So this is just a brief idea about patent. So I will give you one combination of intellectual property product. So laptop or cell phones we all are using. So in laptop, the technical mechanism through which the laptop is operating. So for example, if a laptop is having some kind of face scanner or fingerprint scanner, so these things comes under the category of patents. The hardware codes or software coding parts are there. So that comes under the category of copyrights. The feature, the aesthetic feature comes under the category of industrial design. So one product, multiple intellectual properties. So same is the case with other intellectual properties like copyright. So what are the various things which can be copyrighted, like arts, drama, music, songs? These things can be copyrighted. So from the startup point of view, if someone is having some kind of websites, so that website's contents can be copyrighted. The aesthetic features can be documented and it can be copyrighted. The name, the logo, that can be protected under the trademark law. So these are the various IP laws. So coming back again to the patent law. So for patent, there are certain stages. So first stage is prior art search. So let's say if anyone is having some kind of idea, some kind of product they are developing. So first step is the prior art search. So with the help of someone, you will have to go for the prior art search. You will have to understand that whether this kind of products are available or not. So Google, as a student, you all can use the Google patents. So Google patent is one of the free search database on which you can go and you can search the available patents. So let's say if someone is developing something related to mobile charger or some kind of other products related to toothbrush, so you can just you can just go and Google patents and you can type the keywords. You will get lots of patents out of all those keywords, search keyword result. Then you can have the analysis of the existing products already patented on that name. So that is the first stage, which is known as prior art search. After that, the second stage is drafting the patent documents, understanding the patent documents and drafting the patent documents. So drafting a patent document in terms of techno-legal language. So patent is one of the things which requires the techno-legal language. So technical plus legal language is required. So through techno-legal language, you can go for the drafting the patent. After that, there is the next stage, which is known as filing the patent. So for filing the patent in India, there are 4 offices as per the jurisdictions. So Mumbai office takes care of the like Gujarat, Maharashtra, Goa. According to the jurisdictions, Mumbai Patent Office takes care of these things. Then South jurisdictions comes under the Chennai office. North India jurisdictions comes under the Delhi office. And Northeast also comes under the Delhi office. And Northeast comes under the Kolkata office. So in this way, 4 offices are in India. So first stage is prior art search. Second stage is drafting. Fourth stage is filing. So after filing, government publishes that patent documents so that anyone can see that patent documents. And then government holds it for 2 to 3 months of a span of time. And that span of time, government waits, the patent office waits that if anyone is claiming or any kind of idea has been copied, so someone can claim on that. And after that, there is a process of examination. So again, I am repeating the things. First one is prior art search. Second one is the filing part, drafting part, then filing, and after filing there is a publication. So after publication, the next stage is examination, and as per examination, there is a grant or not grant of the patent. So once you are getting a grant of a patent document, it means that that patent is finally our intellectual property. It's a monopoly right. So once monopoly right is there, then we can enter into the commercialization process and other things. So from the startup point of view, those who are planning to develop some kind of startup, planning to launch some kind of company, if you are working for some kind of products, then definitely there is a requirement of patenting strategy, IP portfolio management strategy as a overall also, not only in terms of patents. If you are having some kind of websites, you are giving some kind of good name, you have designed some kind of good logo, so it must be protected under trademark law. So that see, all the franchisee module businesses runs on the trademark law. So you can see the logo of McDonald's. So it's a M. Then you can see the logo of LG. You can see the logo of Maruti Suzuki. So everyone is having this kind of logo. CCD, Cafe Coffee Day. So they all are having some kind of taglines. Franchisee module businesses runs over this. So if you are planning, if you are developing that kind of startups in your mind, or whether you are working, actually you are working on some kind of startups, you will have to think from the point of IP strategy point of view also. So in this way, you can design the things. Now coming to the next intellectual property, which is known as industrial design. See, design is totally related to the aesthetic feature. So if someone is developing some kind of unique chair, so that is not protected under patent, that is protected under industrial design law. So anything which is having a different kind of shape, size, and feature, so that is protected under industrial design law. Some mechanical device are there, screwdrivers are there. So completely different aspect of designs are there. So that is protected under the design law. So these are the various intellectual properties. One law is semiconductor layout and design law. If someone is developing some IoT based circuits or some kind of electronic circuits, it's a complete new circuit. So that is protected under the semiconductor layout and design law. One IP is geographical indication. So geographical indication like Banarsi sari, Kolhapuri chappal, then Darjeeling tea. So community, those things are taken care by the community. Like Darjeeling tea is taken care by Darjeeling people. Kolhapur chappal is taken care by Kolhapur people. So it's a community rights. So these are the various intellectual property, but we are more focused towards the discussion of patents. So again, coming back to the patent discussion. So patent lifeline is for 20 years. Once you are filing the patent and you are getting a grant of the patent, so from the date of filing, your lifespan is for patent is 20 years. Within that 20 years of a span of period, you can go for the commercialization. You are holding the monopoly rights, and after the completion of 20 years, then it is free to the public. Now I am saying some of the questions. So let's start one by one discussion. So, sir, does Maharashtra come under the South? No, Maharashtra comes under the Mumbai Patent Office, and that is at Top Hill, Mumbai. You can search the Patent Office Mumbai and Top Hill. You will get the exact address. So, second question is there any charges for filing a patent? So, yes, I am coming to the charges part. So, let me complete the basic discussion related to that only. So all the charges part. So there are two categories of the patent filing. One is individual category and another one is organizational category. So individual means me, you, natural person category. If anyone is filing a patent on their own name, then the fees is different. If anyone is filing the patent on the organization name, so then the charges are completely different. So if I am filing it on my name, own name, natural person category name, so for that the fees is like for filing fees, there are different categories. So like if someone is filing through online, for that digital signature is required. So in that case the fees is 1600. If someone is going to patent office and filing it physically, it approximately around 1750 is the filing fees. Then after that there is a certain criteria related to how many drawings are there, how many claims are there in the patent. So based on number of drawings, based on number of claims, the fees may get increased, but it's not too much. Then second category is the organization category. That is in terms of company, in terms of startups, in terms of organization. So in terms of organization, the fees is completely different. So let's say for a natural person, the fees is 1600. So for organization, the fees will be 4 times more. If filing fees is 2200 for natural person, for organization it will be 4 times. So you can say that up to from filing to examination, for natural person it may be cost around closely up to 20,000. Less than 20,000 if you are not taking any external help. I am talking about the fees from the government side. The government fees I am talking. Then for any organizational perspective, the fees is 4 times. So it typically it may come up to 50 to 60,000 because 22,000 is the fees for approximately 22,000 is for examination, 12,500 is for early publication. Then filing fees will be 4 times. So in that way, the total fees will come around 50 to 60,000. So these are some of the basic steps related to the filing and related to the fees part. Now we can take up the exam questions from the startup point of view. Yes.
So I had maybe yeah. So I'm just I can't very help but be drawn to the example of say Coca-Cola, where their recipe has been kept secret for so many years. So
So
now that
that comes under the category of trade secret. That doesn't comes under the category of patent. It's altogether a complete different law.
Yeah, so but my question was that if say I have a certain trade secret which I don't want to reveal to the public, would it be advisable for me to go and patent it or try and register it, or would the burden of keeping it secret would remain on me? Would that be more secure? What would be more advisable for any
See,
person?
if you want to keep it as a trade secret, so we will have to check the norms of trade secret. So I think under the norms of trade secret, it is not advisable to make it public. But for patenting, if you are getting a grant of the patent, under that you are holding the monopoly right. No one is going to commercialize that. If someone is going to take it or someone is going to commercialize, you can file a case against that person or against that company.
So we have one question on the chat box. What
Right.
IP law is applicable to cosmetics industries and lipstick or cosmetic startups?
So if we will have to understand that it's not, we cannot say that it's an overall IP strategy for cosmetic industry. We will have to check it whether it comes under the process category or the product based category or what kind of process has been applied through that. So I will tell you just a simple general rule, like if someone is developing some kind of product related to Ayurveda or some kind of cosmetic product. So let's say if we are combining A product and B product and we want to create C products. So A product must have some kind of own kind of strategy or some kind of features. So in Hindi we say that swagun dharm. So if A product is having some kind of swagun dharm and B is some kind of gundharm. So when we are combining both the A and B and we are creating a C product, so C should not have any characteristic of A and B. C should have completely own characteristic. So in that case, it can be protected under patents. If not, then the second way out for many times they are doing the things like whatever will be the chemical formulations or some kind of formulas they are developing. So they are protecting that formulas under copyright law because it becomes some kind of literature. Coming to the tagline, logo, brand, they are protected under trademark. Yes. I think one more question is there. How long will the entire process take? So it nowadays it is very fast. So it may take up to 2 years. But under startup category, many times it's very speedy and fast. If you're going for early publication, then early examination process, then it takes around 1.5 year of a span of time from filing to the getting the examination process.
So we have another question from Rahul.
Right.
He said that the IT sector in India is more service-based than innovation-based, which ultimately results in a lower patent filing. So how can
Right.
the IT sector adapt to becoming more innovative with patents?
See, as per Indian Patent Act, there is a norms that we Indian Patent Act is not giving the permission for software patent filing. So they are saying that software patents comes under the category of algorithms. But if you are integrating some kind of hardware, then we can go for the patent filing in India also. As per US Patent Act, software comes under the category of patent. That is the one thing. Second thing is the question which I think Rahil has asked this question. So for all of you, in our country, IP policy got launched in 2016, and the awareness related to IP sector, related to patent sector, is not up to that level. Lots of people are not aware about all these things. Even the software industries, lots of software industries, they don't have IP cells. The institutions, academic institutions are not having this kind of IPR cells, innovation cells. So we cannot say that we are not doing that, but it's at very nascent stage. So it will take some time. The next point is, it's not always about the filing part. It's about the developing a product first. So we are not product based economy. We were up to this time, we were the service based economy. Now we all have started this particular things, the Make in India and other kind of lots of provisions are coming up. And now we have started all these things, product development. So definitely it will be there now.
Thank you, sir. There's another
Yes.
question from Siddhant. He said, if I have a patent or copyright, if he patents or copyrights something, then
Right.
would that remain in India or for the whole world?
No, it will remain for India. Let's say if you are filing a patent at Indian Patent Office, it's a territorial right. So Indian government will give us the right for commercialization in our country. If you would like to go for the other commercialization aspect, so we will have to go for different countries filing. So there are different norms for that, different laws for that. So one way is PCT application. So through PCT application, approximately you can enter into the 153 countries. So there are all the countries names are there, some strategies are there, some check boxes are there, and through that you can into different parts of the world. But once you are filing the patent in your own home country, so you are getting a grant on your own home country, monopoly right for that country only. Commercialization aspect is for that country only.
So a lot of people wanted you to come for patent mentoring. So I just want to ask you, for all the startups, how do you think they
Right.
could, a lot of them don't have a lot of legal knowledge. So how could they use patenting, to protect themselves since they're just starting out? And what would be the advice you would like to give to such
See,
startups?
the main thing is one startup founder cannot have all the knowledge of all the things. So for that, there is a requirement of ecosystem. So then there is a requirement of collaborations. So for that, what you can do, you can in nearby area, you can have the collaborations with your nearby ecosystem collaborator, those who are having this kind of mentors. Otherwise, we can help you, we can support you. We at AIC Pinnacle is having the Intellectual Property Facilitation Center. We are one of the Atal Incubation Center in India, received the specific fund for intellectual property facilitation. So you can reach out to us. We are there to support you for IP facilitation related to any kind of activities. In Mumbai also, definitely there must be some kind of IP facilitation center, so you can approach them. And they are having a very subsidized fees rate. Through that, you can enter into this kind of activities.
Thank you, sir. There's another question again from Rahul. He's asked,
Right.
is there a need for transparency in the patent laws of India?
So transparency in terms of what? Is there a need for transparency in the patent laws of India? So transparency in terms of what? So Rahil, you can unmute yourself and please clarify your question.
Yeah, so in case like if a startup say has certain like, do we have to completely have full disclosure in that case, or like sir, sometimes patents can be we'll have to, you like if I'm a startup and I have an idea, Now, how am I supposed to go out and find out whether this has been already done? And
See,
yeah.
okay, I understood your question. So you'd like to ask that if you want to go for patent, how you will understand that this particular product has been already filed as a patent or not, right? Am I right?
Yes, sir.
Okay, so that's why I said you there is a strategy of prior art search. See, no one can claim that this is a complete prior art search. So prior art search means what? आज के दिन तक जो हुआ है, that where we can find that thing. So you can find it through libraries, you can find it through Google, you can find it through Google Patents. So there are multiple patent databases. Lots of paid databases and lots of unpaid databases are there. Through that, you can go for searching that whether this kind of products are available or not. So just let me show you one demo. We are having just, I think, 10 minutes of time. So can I share my screen?
Sure, sir. I think you're a co-host, so yes.
Okay. So this browser is visible to all of you?
Absolutely, absolutely.
So you can go and you can search this Google Patents. This Google Patent search engine is visible or not?
Yeah. Yes, sir. Yes, sir. We can see your Google.
Yeah. So this is not a Google, this is Google Patent. So let's say I've just typed the umbrella keyword. Now you can see there is a result of 1,05,000. So what does it mean? If whatever be the people have filed umbrella or umbrella related patent or any patent where this particular keyword is there. So this will give you that result. Now if you, and all the patents related to umbrella word is here. Now you can just enter here umbrella with charger. So it's a very simple thing. Now see the result, 3,390. There it was 1,05,000 or 50,000, I think, and now the result is 3,390. Now you just check that just by adding one word, what is the search result? So in this way, anyone can check the patents available in the market or patents available in the public domain. But it is not a 100% foolproof search. It's not 100% search. Lots of other databases are there that we will have to see.
So I have a follow-up question for that, which is, does like the existence of so many patents limit a startup's ability to innovate or to grow? Because if you go out and you find out, okay, this is already done or that is already done, then how am I supposed to, as a startup, find new products, find new solutions? Because every time I'd open it, I'd find it's already done.
See, for that, it is not about the limiting, but we will have to check that whether any startup is having any kind of idea, and that is already, if it is patented by someone and they have received a grant, then definitely one cannot enter for the development of product or that kind of services. Because those who have patented and got a grant on that, so it means he or she is having the monopoly right. So then we cannot enter. But you can tweak the things, you can understand the claims, you can understand the current existing position. Many a times what happens that patent filed approximately 25 years ago or some 15 years ago or 18 years ago. So now there can be a possibility that after 20 years, anyone can use that. So then any startup can do, like if you can take the example of ball pen, the pen through which we are writing. So thousands of companies are there. They all are developing pen. So one time it was a patented product, but now it's not.
So we can take a couple more questions, I think. There's another question.
Yes. We are having 10 minutes time. I will just drop off at 2:10. And I will request the organizer that we can have some 2 to 3 hours of session. You can discuss with me my exact time, and we can have some 2 to 3 hours of session related to all these things, related to complete IP strategy, especially. So in that session, I will give you lots of examples and lots of case studies. Today, I'm having lots of other commitments. So sorry for that.
No issue, sir. And yes, we can
Yes,
definitely organize a
yes,
longer, more extensive session
yes,
for
yes,
even
yes.
even startups going forward.
And once this pandemic will get over, I would love to visit your college and I would like to physically meet all of you.
Absolutely, absolutely, sir. Looking forward to it.
Yeah.
So there's a question from Siddhant again. So he's
Hmm.
asking for a recommendation on a book or a website where he could learn probably more about, get more information about patenting or copywriting, IPR, etc.
So lots of databases are there. If you just like to enter into this field, and lots of free courses are available on WIPO, World Intellectual Property Organization. So you can go and you can register yourself over there at WIPO, and free 1 month course, 2 month course, 5 months courses are there. You can have any of the courses on this particular things as per your interest. So that is one of the best way. Another is YouTube. Lots of videos are available, but best is standard is WIPO, World Intellectual Property Organization.
Great, sir. We have Jhalak again asking that if in case there's a patent registered against her company and she did not copy the idea but made some new changes, is it viable for patenting, or how can she save a company in case a complaint like that gets filed?
So anytime once the patent is published, so it is available in the public domain. So after that, you can wait. If someone is not claiming on that, and then there is a process of examination. So in the process of examination, if you are getting a grant on that patent, then it is not a matter of copying. There must be something new or novelty, then only you will get the grant. If you are not getting a grant, then definitely there must be something which is copying. So patent office takes care of all these things. But yes, during the prior art search and during the writing part, technical development part, you will have to wait, and you will have to check that whether you are taking something from somewhere or not.
So there's another question that is there some app or maybe a paid app
Just
that.
just give me 2 minutes. Just give me 2 minutes.
Sure, 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 sure.
Hello.
Yes, sir.
Yes, yes, we can go ahead.
Yes, sir. So the question was from Yash Kotari asking about an app or a, which has a search option about a patent that is already registered. Is there some function like this?
Sorry, I didn't question. I didn't receive that question. Is there some app, maybe paid app, to search about patent already registered? See, lots of databases, paid databases are there through which you can go for the understanding that whether this kind of patent is already registered or not. PatSeer is one of the paid database, which still is one of the paid databases. Through that, someone can understand.
So we also have one more question, which says the AI technology is advancing rapidly, and is there a need for patenting laws to come and become more accommodating?
Right. So our government office is working on all these things, that how the AI can play a role for the patenting. But as per my knowledge, we have not received the any specific general rule related to AI and patents as per date. But very soon it is expected that we will receive something.
So also Siddhant asks one more question. If something is patented or copyrighted in another country, but not in India, can I patent it and copyright it in India?
You will not get a grant out of that, because if someone has patented that in another country and once we will go for filing in our country, so that will come under the prior art search. So it kills the novelty part. So let's say if someone has filed something in US and we are filing in India, so once we will go for the prior art search, or if patent office will go for prior art search, so it will get reflected somewhere. So likely very less chances, but many a times happens that also.
So also, like, I think we have one last question, which is
Right.
there any reasonable degree of differentiation between products which can allow me to, evade certain patent laws, or, something which is similar to a product, but not the exact same. So I don't have to actually be subject to a copyright infringement or a patent infringement.
Can you repeat this question once again?
So in products or in patenting law, is there some reasonable degree of differentiation where I
No.
can?
No. As per any IP law, not there is any degree of differentiation. It's all about the interpretation. They are giving you the clauses, they are giving you the sections, they are giving you the subsections, and as per that, there is three criteria: novelty, inventive steps, and industrial application. Now it's always interpretation, that how you are representing the things, how you are writing the claims, how you are projecting it in front of the patent office.
So do we have time for one last question before?
Yes, last question you can take.
Sure, sir. So there's a follow-up to the question before, and Jhalak again asking that she's saying that she has the same question as Siddhant, but in her question, say the company is in outside countries, and the other company is in India.
Company is okay. What was that question? I think she asked related to the something developed, something modified, right?
Yes, sir.
That was
Yes.
the question. Okay. So Jalak, you can unmute yourself and you can ask me the exact thing which you would like to ask.
Okay, yes, sir. So imagine if my company is in outside country, but the company that has filed the complaint is in India, and I have not copied the same question. Like I've not copied
But
that.
where that IP is filed, that is in India or that is outside India?
No, the IP is filed in India, but the company is outside India. In that case.
But who is filing that in India?
Like if I open my own makeup company, then some other company same company in India is filing a patency against some other makeup company. In that
So
case.
you can take this as an example that let's say if some cosmetic company is in US and now we are developing something same in India and we are filing IP for that. So
Yes,
that US company must have protected all these things under different law. There is a recent case for it was not exactly case, but we have witnessed something in the newspaper, the big basket and some more another thing who is using the basket name. So there was just a conflict for using the basket name. So who have protected the basket name? Yes, Daily Basket, exactly. So Daily Basket and Big Basket. So that was the controversy going on. So we will have to understand all these things, that what is the actual protection of that company. Then we can design our own IP strategy for that.
Okay.
I think
there is not any clear-cut formula for all this thing. It's just like a doctor and patient relation. We will have to understand the things. What is the problem? What is the actual requirement? And based on that, we can enter into this kind of IP strategies.
Okay, sir.
Yes.
Thank you, sir.
Thank you. So Siddharth, I think I have shown these seats to all the participants, and you can please discuss with your heads of the institutions, and definitely with all as per availability of everyone, we can plan this particular things for a long span of time so that we can enter into lots of discussions.
Sure. Sure, sure. So thank you for taking out the time. Even in such a short span, you could give us a very structured masterclass on patenting and even take up the questions on a larger scale. And thank you for
Right.
always supporting us. And we hope to
So
see you
thanks
in
a
the
lot to you. Thanks a lot to all the participants. Thanks a lot to the principal director of Jai Hind Institution. And thanks a lot to Dr. Rakhi Sharma for coordinating this great event. And from my side, from the AIC Pinnacle side, best wishes to all of you.
Thank you. Thank you so much. Thank you.